going to call...
Come on,
Chris
Mr. Chair.
Hipkin. The Honourable Member Chris Hipkin. He hasn't had a call yet.
Thank you very much, Mr. Chair, and I'm happy to have the first of what I hope will be many calls on the Government Communications Security Bureau and related legislation amendment bill. And I want to go immediately to one of the detailed clauses in this legislation. For members who are following along, page 9, clause 8CA 3C is the clause that I intend to talk about. And that clause states that the Director must take all reasonable steps to ensure that the Bureau does not take any action for the purpose of furthering or harming the interests of any political party in New Zealand. And I think that's actually a very important clause. It's a clause that I support, but I want to consider how much faith New Zealanders can actually have that that clause will be followed. Given that the Director that that clause refers to is a childhood friend of John Key's, was appointed without proper process, handpicked by John Key to do the job, without the proper process that would normally go around that, and reports directly to that same person, John Key. How can New Zealanders have confidence that he will discharge his responsibilities in a politically impartial and neutral manner? Because let's make no bones about it, this government are very, very happy to exercise the power of the state when it comes to protecting their own personal privacy and their own information, but not so concerned when it comes to the privacy and the personal information of every other New Zealander. So let's consider how this bill came about being in the first place. The matter of the Kim.com fiasco. One of John Banks's biggest campaign contributors, was being illegally spied on by the GCSB. And when that became apparent, we all know what happened. Absolute chaos reigned. And now this legislation is being brought into the House because the government had acted illegally in with regard to something that has become a very, very political manner. Then let's consider that the very same Mr. Banks sat down for a cup of tea with John Key, which we all now know about, the whole country knows about, and the government did not hesitate. John Key did not hesitate to use every avenue available to him to ensure that the contents of that conversation did not get out. When it became apparent that that conversation had been recorded, he did not hesitate to send the police in to raid the offices of the media. So any pious statements we hear from the government now about protecting the Fourth Estate, we know that's pretty hollow, because when they hold information that might be damaging to John Key, he didn't hesitate to have their offices raided in an attempt to try and get that information back. And if the allegations that we heard yesterday are correct, he also had the police accessing the phone records, or attempting to access the phone records of someone else, a private citizen who may have had information, a very modest private citizen who may have had information relevant to that particular investigation. And I think that means that New Zealanders cannot have any confidence that this clause that I'm debating now, that requires the Bureau to act in a way that is effectively politically neutral and not acting to the benefit or the detriment of any political party in New Zealand, I don't think that we can have confidence that this clause will necessarily be adhered to. If we move to that same section 8CA and look at clause number 1, the very first clause in that particular section, in performing its functions under this Act, the Bureau acts in accordance with New Zealand law and all human rights standards recognised by New Zealand law, except to the extent that they are in relation to national security modified by an enactment. Now, I thought that was very interesting, because we've got some very good laws around human rights in New Zealand, the Human Rights Act, the Privacy Act and so on, and I wanted to get a good analysis of how this proposed law change might impact on those. And it's really, we rely as members of Parliament on a thing called the Regulatory Impact Statement to give us that information. The Regulatory Impact Statement will almost always contain an analysis of the implications on the Human Rights Act, for example, of a proposed law change. So I read the Regulatory Impact Analysis that was placed on the table earlier today, and it does not do that. It does not go through and give us details about how this legislation will impact on the New Zealand Human Rights Act. So I think that's really important, because if we come back to this clause, it says that in performing its functions under this Act, the Bureau must act in accordance with New Zealand law and all human rights standards recognised by New Zealand law. And I think it's very reasonable to ask, to what extent are those very laws and standards infringed upon, Mr. Chair? Mr. Chair? Mr. Chair?
I call the honourable member Mike Sabin.
I move the question be now put.
Thank you. Order. Order. I can't hear.
Point of order.
No. Sorry.
Point of order.
Point of order. The honourable. I said no. Okay.
Point of order.
The honourable member, Honourable Mary Ann Street.
Thank you, Mr. Chairman. At the end of my speech before, I wish to table the advice of the Regulations Review Committee to the chairperson of the Intelligence and Security Committee, spelling out the inadequacy of the legislation in its first draft.
Can I just ask the member, has it been publicly released?
It was only released by the Regulations Review Committee this morning, which I chair, Mr. Chairman, and it may not by this stage yet have gone up on the website, on the parliamentary website. I don't know that. So, no, it hasn't been in the public domain previously, and it is relevant to this debate, and I would like to table it so that members can have a look at it themselves.
Well, if the member has released it, then she's perfectly entitled to seek leave. The member has sought leave. Any objection? Maybe the member... Leave has been sought.
Leave to table the Regulations Review Committee advice to the Intelligence and Security Committee. It's not been.
It's been objected? Yeah.
Mr. Chair. Mr. Chair. Mr. Chair.
Well, I see that Mr. Horan has an SOP, so I will call the honourable member Brendan Horan.